Welcome everyone to this short podcast. I am Purushotham and I am a part of the International Disputes and Investigations practice at Nishanth Associates. I have with me Anirudh Arjun, a senior member of NDA's private equity and M&A practice, and Nishanth Kadur, a leader in the International Disputes and Investigations practice. Now today we are going to uncover some interesting issues around standard arbitration clauses. Famously or infamously, clauses like this, which are typically overlooked, are referred to as midnight clauses too. I am quite intrigued to understand today from my colleagues what concerns these clauses throw up from the lens of a transaction lawyer and an arbitration practitioner. Anirudh, the first question to you. Now, I believe the name midnight clause comes from the fact that the arbitration clause is not given enough attention by any of the parties. Being a deal lawyer who does considerable amount of PE and M&A transactions, can you tell us how significant the negotiations and discussions typically are around this arbitration clause?
Thanks, Guru. Typically, in several transactions, certain points, often involving commercial interests, take precedence over other clauses at the time of negotiations. For example, in any PE M&A transaction, we usually see parties spending a considerable amount of time negotiating clauses relating to governance and investment protection. This is of course understandable because investors would want to secure the rights surrounding their commercial interests. Sometimes certain other clauses in a contract are not paid enough attention to, like perhaps the dispute resolution clause, which typically provides for arbitration in case a dispute arises between the parties in the future. Thankfully, we are now seeing that trend slowly change, with the contracting parties themselves being particular about ensuring that the mechanics of the arbitration clause is suitably tailored.
It's interesting that you note that the trend is changing. Thanks, Anirudh. And it is perhaps changing because we have seen a number of disputes arising from inadequate or improperly drafted arbitration clauses. Nishanth, could you shed some light on such clauses?
Sure, Guru. So when an arbitration clause is not properly drafted, we see several issues that can arise if it goes into arbitration, if a dispute goes into arbitration. Right? I'll give you a few examples. The words used in an arbitration clause will determine the scope of an arbitration clause. And sometimes parties use unnecessarily restrictive wordings in the arbitration clause. Now, what that leads to is elaborate arguments in the arbitration and perhaps even before a court when it goes up in set-aside proceedings or enforcement proceedings that the dispute did not even fall within the arbitration clause. So, appropriately wording the arbitration clause becomes very important. Another type of disputes we see is where the parties don't mention the seat of arbitration. And the seat is a very important component of an arbitration proceeding as it determines, among other things, the jurisdiction of courts as well as the law applicable to the arbitration proceedings itself. Now, one last example, and I can give you a lot more examples, but one last example is the governing law of the arbitration agreement. And this is important in international arbitrations. The governing law of the arbitration agreement determines, among other things, the validity of the arbitration agreement itself. So when there is a dispute relating to that and the arbitration clause does not provide which law governs the arbitration agreement, considerable amount of arguments are led and considerable time and effort is spent in determining what the law applicable to the arbitration agreement is, which could have been avoided if the clause simply provided for it.
Thanks, Nishanth. That was some very pertinent issues that we have touched upon and with both of you. And now I'll throw this question to both of you to conclude. From all the issues that were spoken around surrounding arbitration clauses, what are then the key items to keep in mind when these clauses are being drafted and negotiated to avoid such disputes? Anirudh, I'll let you take the first crack, and then Nishanth, maybe you can also add your thoughts.
Thanks, Guru. My short answer is that it is extremely important for persons who are drafting the arbitration clause to have a basic understanding of the process of dispute resolution itself prior to drafting such clause.
Yeah, I agree with Anirudh. And just to add on to that, I would say that enough time and attention should be given when the arbitration clause is being drafted and when it is being negotiated between the parties. This certainly would help parties avoid spending a lot of time and effort if at all a dispute arises from that contract.
Thanks Nisha, and thanks Anirudh. Both of you had given us very insightful views. It may be safe to say that midnight clauses are only a threat if we don't focus on the fine print. With that, I thank our listeners for tuning in, and do look out for more such podcasts from us at NDA. Thank you.